Good evening, everyone. Please may I request everyone to be seated. Thank you. We've had some excellent exchange of ideas today throughout the day, and I thank all our panelists for their valuable contributions. May I now invite Mr. C.K. Nandakumar, Senior Advocate of the High Court of Karnataka, to introduce our distinguished chief guest, Honorable Justice Krishna Kumar, for the keynote address. Thank you.
Thank you. I've actually taken a printout after quite some time. I've drawn inspiration from all the preaching about technology and have tried to move paperless as much as I could. Good evening, everybody. Honorable Justice Sir Krishna Kumar. Indeed an honor to introduce you. Friends present here, old and new. Thank you, Neeti, for this opportunity, and thank you, MCI, for putting together this wonderful event. I see some friends from Singapore and London. There was a Singapore Disputes Week last month. I could not make it for a very important reason. We had an ADR week in Bangalore of our own. And congratulations to those organizers, many of you are here. Planting a firm place in the ADR landscape, use of technology in arbitration and the future of such disputes, shareholders' disputes. These are some of the topics that and themes that were discussed over the course of the day today. Arbitration conferences, or conferences in general, are a great opportunity to reorient ourselves, but arbitration conferences in particular are an opportunity to reorient ourselves to this alternate universe, which sometimes simply doesn't understand the court process. And the court process, for its part, is sometimes completely befuddled by what goes on in this alternate universe. There's a very famous saying in the arbitration world that ultimately you may have to go to the state courts for enforcement because that's where you're going to get your money from. So the interplay between the state courts and arbitration is a very vital interplay. This interplay is one that should know its clear boundaries, respect one another, especially in the increasingly complicated world that and scenarios that we see. How much court intervention is acceptable? How detached should arbitration be? I don't have the answers. I hope Justice Krishna Kumar would have some of them. One of the main concerns that's often pointed out is the conduct of arbitrators or arbitrations. Ethics and matters of conduct are something that typically catches a judge's eye, possibly more than the merits of a matter. We do look forward to some very insightful remarks from the bench through Justice Krishna Kumar. That's not to say that he's an outsider. Let me just make that clear. And I'm sure I speak for every member of the bar present here that he's one of the most popular judges, and I'm not saying this just to flatter him. It seems like he's still one amongst us, the manner in which he puts us all at ease. He somehow manages to keep tempers at bay and both parties happy at both, in most cases. A truly gifted person. Perhaps a born mediator, one might say. But anyway, I'll skip the bit where I have to make the remark about when he was born and how old he is, out of courtesy. But Justice Krishna Kumar joined the bar in 1992. He has had an extensive practice on civil and criminal matters and several other areas. Incidentally, he was appointed a judge 5 years ago to the date, 23rd September, 5 years ago. So congratulations, it's been a wonderful 5-year journey. But I can say without any fear of contradiction that he's somebody who's well aware of the balance that's needed between court intervention and the independence of arbitration. Therefore, if anyone has any remarks or concerns to share, we should all sit up and take notice since it's coming from Justice Krishna Kumar. Without holding him up any further, ladies and gentlemen, Justice Krishna Kumar. Sir.
Efforts to enhance diversity help ensure that ADR reflects the varied backgrounds of the parties involved, contributing to perceptions of fairness and representation. In this context, prioritizing the nomination of women as court-appointed arbitrators is an important step towards addressing the long-standing criticism that arbitration has been dominated by male practitioners, as highlighted by Honorable Justice B.V. Nagaratna in a recent ADR week at the Karnataka Judicial Academy. Promoting women in these roles not only challenges the male preserve of arbitration, but also enhances gender diversity, which is crucial to ensuring that the process is more representative of the society at large. Recently, once again, Honorable Chief Justice Chandrachud has emphasized the importance of appointing young lawyers also as arbitrators, ensuring that the talent pool remains diverse and inclusive. This move encourages a dynamic mix of experience and fresh perspectives, helping to foster innovation while maintaining the higher standards of competence. These efforts to enhance diversity go beyond mere representation. They ensure that ADR is continually evolving to meet the needs of a global and multicultural society. By encouraging inclusivity, ADR institutions can strengthen the credibility of the process and ensure it is perceived as an equitable and just by all participants. The ethical code of conduct of parties and counsel is equally important. Engaging in ADR with sincerity and in good faith fosters an environment conducive to open communication and collaboration. Upholding ethical norms enhances the effectiveness and fairness of the process for all participants. Transparency in arbitral proceedings involves ensuring that the parties fully understand the procedures and that there is consistency in their application. Clear communication and openness about the process to contribute to trust and can prevent misunderstandings. While confidentiality is valued for protecting sensitive information, finding the appropriate balance with transparency is important, especially when broader interests are at stake. Institutional transparency is also vital. Many ADR institutions like the MCIA have made significant strides in enhancing transparency by providing clear information about their rules, fee structures, and appointment processes. These efforts help parties make informed decisions and enhance confidence in the institution services. The use of technology, I think one of the sessions was about use of technology. Also in ADR, also introduces new opportunities and considerations. I think much has already been spoken to and discussed, so I will not dilate much on the use of technology. Then we come to developing and implementing ethical guidelines is a collective effort involving international frameworks, national initiatives, and institutional code of conduct. International standards such as the International Bar Association IBA guidelines on conflicts of interest in international arbitration provide valuable guidance for managing conflicts effectively. The UNCITRAL rules on transparency is a treaty-based investor-state arbitration. Treaty-based investor arbitration promote openness in proceedings involving public interests. In India, the Arbitration and Conciliation Act 2019 amendment introduced confidentiality obligations and established the Arbitration Council of India to promote ethical practices and standardize the arbitration process. Institutions like the MCIA have been proactive in promoting ethical conduct through comprehensive rules and guidelines. The MCIA Code of Conduct sets ethical standards for arbitrators, including disclosure requirements and guidelines for impartiality. Such initiatives contribute significantly to enhancing the credibility of arbitration proceedings conducted under their auspices. Training and accreditation are essential for promoting ethical practices. Regular training programs on ethics for arbitration, for arbitrators, mediators, and counsel enhance awareness and adherence to ethical standards. Leveraging technology responsibly is crucial in modern ADR practices. Using secure platforms ensures confidentiality and data protection. Developing guidelines for ethical use of artificial intelligence in ADR can also help maintain trust in technology-assisted processes. Then, let's look at promoting procedural transparency, which involves providing clear rules and procedures that are accessible to all parties. Institutions should establish feedback mechanisms that allow parties to share their experiences and suggest improvements. ADR institutions play a vital role in addressing ethical and transparency concerns. They lead in creating and enforcing ethical guidelines, offering resources and training, and promoting best practices. Practitioners, including lawyers and neutrals, have a responsibility to uphold ethical standards and advise clients accordingly. By engaging in ongoing self-assessment and professional development, They clearly contribute to the credibility and effectiveness of ADR. Collaboration among practitioners, institutions, and regulatory bodies can also strengthen ethical practices and address concerns. International collaboration can help share best practices and mutual understanding in cross-border ADR, respecting the diversity of updating of legal systems and cultural norms. As we conclude this enriching session of the ADR week hosted by the MCIA, it is evident that ethics and transparency are not merely topics of discussion, but fundamental principles that will shape the future of alternative dispute resolution. Throughout today's event, we have engaged in insightful dialogues and shared experiences and explored innovative approaches to address the challenges we face. The collective wisdom and commitment demonstrated here reinforce our shared vision of an ADR landscape that is ethical, transparent, and effective. The challenges of balancing confidentiality with transparency, embracing technology responsibly, and promoting diversity are opportunities for growth and collaboration. I extend my deepest gratitude to the organizers, speakers, and participants who have made this event a resounding success. Your dedication and passion for advancing ADR inspire confidence in the path ahead. The MCIA's efforts in facilitating such a platform have been instrumental in fostering a community committed to excellence and integrity. As we move forward, let us carry the insights and connections we have gained into our professional endeavors. By upholding the highest standards of ethics and transparency, we not only enhance our individual practices, but also contribute to the greater good of society by ensuring that justice is served fairly and effectively. Together, we can shape a future where ADR stands as a beacon of fairness, efficiency, and trust. Let us continue to collaborate, innovate, and lead by example, reinforcing the values that are essential to the success of alternative dispute resolution. Thank you so much to all of you for your engagement, your contributions, and your commitment. Thank you.
Thank you, Justice Krishna Kumar, for your presence today and for your insightful address. Since you mentioned having a large pool of arbitrators, I'm pleased to inform that MCIA has done over 40% of appointments as first-time arbitrators, and I'm pleased to be part of the young MCIA. May I now invite Mr. Pramod Nair, Senior Advocate, High Court of Karnataka, for his concluding remarks. Thank you.
Thank you, everyone. Thank you, Justice Krishna Kumar, for your keynote address. I think for those of you who practice in Karnataka, Justice Krishna Kumar's quote is probably one of the most popular quotes. There are judges who walk the extra mile to do complete justice for parties. I think Justice Krishna Kumar doesn't fall within that category. He doesn't walk the extra mile. He probably runs a full marathon. And he sits well into lunchtime, he sits well after court hours, and he makes sure that everyone, litigant, lawyer alike, who leaves his court, leaves with the assurance that they've received a full hearing, a full consideration of the case, and that justice has been done. And I wouldn't be surprised, sir, if there are statistics which show that probably your judgments must be the ones that are the least challenged before an appellate court. So thank you very much for your concluding address. And I think every theme that was touched upon in the keynote address, ethics and transparency, the need to further enhance diversity, the need to harness technology, especially AI, and the need for cross-border cooperation and learning are all themes that we will fully explore in the various sessions that unfold during the India Arbitration Week. I know that I'm standing between you and dinner, so let me just make a couple of observations and then propose a couple of agenda items for MCIA and every other Indian arbitral institution to help take the arbitration movement further. India got its first chess grandmaster in 1988. This year, we've got a total of 85. Now, what does that have to do with arbitration? I think what that has to do with arbitration is in 2011 or 2012, when the first international arbitration conference was organized in Bangalore, Neeti, I'm not sure whether you were formally with the LCIA India or whether you were interning at that point in time. But I know that Neeti, Ajay Thomas, many of the members of the LCIA court were working the phones, were sending emails to make sure that we could have 50 to 60 people attend an arbitration conference in Bangalore. In a few months back, when the SIAC held its event in Bangalore, the number of people on the waiting list and the number of regrets that they sent exceeded 300, simply because the room could not accommodate the number of people who wanted to come and hear and discuss about recent developments in arbitration. That's how the field has grown from 2011 or 2012 to 2024. And therefore, whilst we've made the journey from one grandmaster in 1989 to 85 now, and yesterday I think there was a news report which said that India has won both the women's and men's chess championship. I think it's also a theme which resonates across the world. Davinder Singh, the chair of SIAC, made a very pertinent point, which is that the question now is no longer whether there are enough Indian practitioners who can competently practice arbitration, both as counsel and as arbitrators, but whether there are enough arbitrations in the world for this massive influx of really qualified, competent Indian arbitration practitioners who are knocking at the doors of institutions, asking for their first arbitrator appointments. You see them increasingly acting as counsel in arbitrations, not only in India, but across the world. And that's actually a very good problem to have as Indian practitioners. So that's one observation that I wanted to make. Two very quick proposals or suggestions that I would make for MCIA India and for everyone else, probably something to be discussed during India ADR week and later as well. Sometimes many of these conferences, many of these ADR weeks, etc., end up being a little bit of crib fest about certain controversial judicial decisions. Nothing wrong with that. I think it's important to critically evaluate and analyze judicial decisions. But why don't we think about finding a solution for that? There is a wonderful inspiration that we could probably take some inspiration from. There is a document which is called, which crystallizes the interpretation of the New York Convention, which is the inspiration for the Indian Arbitration Act of 1996. Part 2 of the 1996 Act is essentially the New York Convention. There's jurisprudence from all across the world which has been crystallized in a book called The Guide to the Interpretation of the New York Convention. Why can't we produce a guidebook for judges who interpret arbitration awards? So the contours of interpretation, the contours of Section 34, what is permissible, what falls outside the boundaries of Section 34, Section 37, etc., is something that would go a long way in harmonizing the growth of Indian arbitration law. It will probably be a force for the good in making sure that you have more consistency in arbitral decisions right from the commercial court all the way to the Supreme Court. That's probably one agenda item that I would very humbly propose to the MCIA. The second, and this is probably one of the most important themes of the recently concluded Bengaluru ADR Summit, which is the need for training and capacity development. How to draft a good arbitration clause, how to run an arbitration efficiently in the most efficient manner with minimal cost and in the fastest possible way. How to draft a good and enforceable arbitration award. You have wonderful talent, and it's a wonderful initiative that the Supreme Court has developed over the last few months, which is to appoint young arbitrators. But how many of those arbitrators actually trained in writing a good arbitration award? And isn't that something that we really need to focus on? It's very good. That's one side of the equation. But we also need to make sure that they have the skills and the ability to deliver when they're appointed to a number of these domestic and international arbitrations. So therefore, one more agenda item that I would add to your list is to have some sort of a mentorship scheme. We've had a number of pledges in the arbitration world. We've had the arbitration pledge to increase the number of women arbitrators who are appointed across arbitral institutions. That's proved to be incredibly successful, and it's continuing to be even more successful as the years pass, including in India. There's also now the India opportunity, which was launched a couple of years back. So may I propose a mentorship pledge where a senior arbitration practitioner takes under his fold or her fold a minimum number of 4 trainees, typically people who would be less than 10 years of experience, to train them in being good arbitration counsel and being good arbitrators, share with them precedents of good procedural orders after redacting all confidential information, provide templates of good arbitration awards, provide templates of what makes for a good claim statement, a good statement of defense, etc. And I think that knowledge sharing and that mentorship is something which this generation probably has a responsibility to impart to the next generation of arbitration practitioners. All of us have been incredibly lucky to ride the wave of the growth in Indian arbitration, and I think we can pay that on forward. So with that, let me invite you once again to dinner, which is next, and to another 4 days of serious deliberations over India Arbitration Week. And I think the highlight this year is probably for the first time a cricket match in New Delhi. So for those of you who are interested in donning your whites, then there's a cricket match happening at the end of this week. So look forward to seeing many of you at many of these events over the next few days. Thank you very much, and thank you very much, Justice Krishna Kumar.
Thank you, Mr. Nair.